This is David Cowen with Careers in the Business of Law. I have an incredibly special guest today, the Godfather of eDiscovery, former U.S. Magistrate Judge Andrew Peck. Nicole Giantonio, the Global Chief Marketing Officer of Epic, is going to be my co-host today to help keep us on track. And Judge, you and I have known each other for a little while. You've literally written some of the most important chapters in the legal tech revolution. And if I can, I'm just going to set this up for the audience. What I really want to hear from you, and I think what we would love to hear from you today, one, a little bit about your new role at DLA Piper, new role for you, and I think maybe for DLA as well, what that's all about, but the similarities and differences between where you were 20 years ago with the Zubilate case and how that sort of jumped onto the scene. What you see maybe as the three top concerns today as AI and agents begin to enter this, what's defensible, what's not defensible. And then I think Nicole and I will just kind of have some fun riffing together. Judge, welcome to Careers in the Business of the Law. How are you?
Happy to be here. Good to see you again. I think that, 20-something years ago or whatever, we spent the most time together at first in Australia at Sheehy's conference. I won't even mention the firm name. But yes, that was a nice boondoggle, I must say.
It was fantastic. It was 20 years ago. It was the harbor. It was in Sydney, Australia. And the restaurant that we were all going to literally burned down in front of us as we were walking from the hotel to the restaurant. The fire trucks are going. And I looked at you and you looked at me and we looked across the harbor and we said, well, let's just go there and take it over. And we did indeed just sort of commandeer 5 restaurants and split the whole group of 100 and some odd people up amongst those restaurants. And I think we have been talking about Sherlock Holmes ever since. Tell us about DLA. What are you doing at DLA these days?
I'm in the copyright and trademark group. That's my substantive area of some skill, but mostly, not surprising to you, I'm sure, I'm doing eDiscovery consulting, eDiscovery work in particular cases. And of course, as we are starting to get into the heavy season, lots and lots of speaking at eDiscovery conferences.
So I know Nicole has a question. Nicole, I'm going to come to you in 1 second,
Sure.
but I just can't not ask this question. Does this feel like deja vu all over again, to quote Yogi Berra?
The great philosopher, yes. It does. Doing some, defending depositions, et cetera, that I've lasted 30 years ago. One never gets out of the ability to do that. But, as a senior counsel at DLA, I sort of can do what I want. So that's different than being an associate at a different firm many, many moons ago before I went on the bench. And, in the be nice to people around you, the person who recruited me to DLA, the person who is the chair of our copyright and trademark group, is my former law clerk. So it's,
That's fun.
Very familiar territory in that sense.
Yeah.
Nicole, one of my favorite things about always working with you and having you on the show is your point of view and your perspective. You've come from private equity. You have, you've got it's not statistics. It's your background is in statistics and private equity and doing deals, understanding numbers. And here you are at Epic, and how you made that journey into the global chief marketing officer of this billion-dollar plus legal services behemoth. If you would please introduce yourself, and then let's get into defensibility and what's happening in the world today.
Great. Thanks, David. I appreciate it. Love being on. Love, of course, doing podcasts with you. And Judge Peck, I'm a podcast fan. So it was a big part of how I learned about legal. I interviewed a few hundred legal managing partners at law firms, general counsel, legal operations professionals. And I've met David along the way, and we've had the opportunity to do this a few times. Of course, our interest at Epic, we are heavily invested in legal technology, and we are pro AI. We want to do the right thing by our clients, whether they are a law firm or legal department clients, and we want to produce technology that they can use to make their roles just be more efficient. Give them access to data that they wouldn't have without this great technology. So I think, David, if you're okay, I'm going to just dive in with a few questions for Judge Peck. Does that work?
Yes, please. Go. Let's go for
Excellent,
it.
great. So, Judge Peck, there's, obviously you were part of the beginning of AI. I always talk about AI in our industry has been here for, at least 10 years, definitely more like 15. In the early stages. You can see it when we're out at conferences. It trickled in and then it just took off. So, in your opinion, what's the difference? Why is AI different today, and maybe the defensibility discussion different today than it was? And of course, we can talk about agents and LLMs and all of that. But what's the key difference from your seat?
I think the difference is back in 2012 when I wrote the first opinion accepting the use of technology assisted review, TAR.
Yeah.
It was more of a black box to people. Those within the industry started learning about it, but the rest of the world, what's tar? That's what you pave the road with. It doesn't translate over. Now, everybody is interested in playing with GenAI and similar tools. And that is both good and bad. It means there is more awareness about the tools and to some extent how they work. The bad is, as we've all been seeing, Gen AI tools, like young children or whatever, they want to make you happy. So if you're asking them to look for a case citation on the use of TAR, they may or may not find my De Silva Moore opinion. If they don't, they'll find something else, which may be a real opinion, or it may be a hallucination opinion, which is the polite way our industry is calling fake citations, hallucinated.
Right.
And that worries me a lot, because that, the first of those cases to really hit the news is now 2.5, 3 years old. Mata against Avianca in my old court, Southern District in New York, Judge Kevin Castell. And that was the first one that got any publicity. And my thought was, this hit the New York Law Journal, it hit the New York Times, it hit all the mainstream press. Lawyers are now aware and will be careful, and et cetera.
Right.
We are now up to 160 or something like that hallucinated cases, and judges are not happy, to put it mildly, and I suspect a lot of clients are not happy. The fact that people are still using Gen AI for legal research without appropriate safeguards is a scary thought.
Let's talk about the safeguards, though, because that is really where, organizations like ours, companies like ours are going, right? Like building in and showing, that, hey, these aren't closed walls. This is private. We're citing every piece of information we're putting forward. Are you feeling comfortable that organizations like Epic and the other suppliers of this technology are taking this seriously and really trying to provide and are providing things like citations for every points that we're putting forward?
I think so, yes. And,
Yeah.
that is the safeguard that is going to save us from hallucinations in using Gen AI type products for eDiscovery work. But, there is still the name or reputation of Mata against Avianca and all its too many follow-ons. And so I do worry about what judges are going to perceive this at. The other issue is the fact that, you have these safeguards that the tool will say, I am ranking this document as relevant and not privileged because, and then quote a little or summarize the document. That's all great and should make the producing party very comfortable. The question is, what's the requesting party going to say about that? And
Right.
we're already seeing the debates, fortunately, not in case law yet, but at the eDiscovery conferences of
Yeah.
should that be discoverable? Should the prompts be discoverable?
Right.
Should that, summary of why the document is relevant, et cetera, should that have to be produced to the requesting party? I don't know where we're going to come out with that, hearing requesting parties say we want it, and responding parties basically saying over my dead body.
Yeah.
We got to figure this out. And I think my biggest concern and perhaps biggest lesson for today is the lawyers have to be careful which judge they're going to take the first case about using AI for eDiscovery in front of. If it's somebody young enough or in tune enough, then that's one thing. If it's a Neanderthal, the first case that criticizes the use of GenAI for discovery is going to set us back 5 to 10 years in its use.
So
go ahead, Dave.
So I just want to recap that because it went quickly. And if you're not familiar, maybe that was a little bit fast. So let me just recap that. Did I hear you say what data got pulled, how the data is pulled, and who pulled the data is the issue with AI today? And that the who, if it's agentic, is a problem? Is it what, how, and who?
Well, the question is, are prompts, whether agentic or other, the equivalent of keywords? And so when we were in the old keyword days, you had to exchange your keywords and vet it with the other side, and how many hits were returned from that keyword. Is that too few, too many, or Goldilocks just right? Or is it lawyer work product? This is how I think about finding the right documents within the corpus of the ESI, and therefore it's work product privileged, if not attorney-client privileged, and it doesn't have to be produced. I don't know what the answer is going to be on that, but that is clearly a thing where I think the requesting party is going to have a very different view than the responding party.
It's interesting. One of my colleagues wrote something and they said that there is no requirement to disclose the evaluation metrics, such as precision and recall. But you have to show, that they were calculated or how they were calculated. So I think I bring this back to what you were just saying, Judge Peck, is that whatever judge this goes in front of has to understand this, and it's complicated. And, David, I look at this as like, this whole thing between the producing party and the requesting party is similar to when, we saw in the movies, people would the truck would back up at the big boxes of documents, right? Like it's the same idea, right? Like the more complicated this gets, you're going to have different counsel basically saying either they understand it, don't understand it, have to call in their specialists in their firm to come in and talk about whether what has been produced is valid or used valid methodologies, let's say it that way. So, I mean, Judge Peck, do you see that is the big issue for law firms, is that they have to now have people that understand it well enough to be able to say, yes, this was an appropriate, I guess the point would be appropriate gathering of information, let's say it that way, or gathering of content.
Yeah, and whether it's the lawyer from the producing firm or whether it's an outside expert they hire to explain it to the court. I used to say in the good old-fashioned tar days, bring your geek to court day,
Yeah.
and like in patent where you do a science day for the court, it's almost never done on discovery matters. But yes, somebody has to explain this to the court. Now, there are some judges who are, well ahead of the curve and knowledgeable, whether they are using it for work or just using it in their private life. One of the West Coast magistrate judges, is talking about her affair with her boyfriend Claude, because she's one of the ones who uses the Claude tool. Could have been Harvey, could have been whatever, but
Yeah.
and she knows it, and knows how to use it at least up to a point. But we've seen, as a response to matter and hallucinations, we've seen some judges creating local rules or their own chamber's rules, some of which show they clearly don't understand what they're talking about, with no offense to, my former judicial colleagues. It's one thing to say, if you're going to use GenAI, you've got to do X, Y, or Z. It's another to say, if you're using AI, you've got to reveal it, explain it, etc. Well, that would cover TAR, which is a form of AI. It would cover spell check and grammar check and all of those things. And I don't think that's what the judges who badly phrased their rules were really looking at. So it's really a question of everybody understanding it. And, if a lawyer comes in before a judge, whether a knowledgeable or not a knowledgeable, and is asked, well, okay, you're telling me you used a GenAI tool, how does it work? And the answer is,
Right.
I don't know, or all I know is it works, Judge. Trust me, that's not going to go over very well.
Do you see these as very different things? Because I do think, we talk about Gen AI and producing and using tools like a chat GPT or something that's more versus TAR, technology like, our, discovery technology that has been advanced, either Epic's or someone else's, that does include large language models. These tools are very advanced. I mean, they're very advanced in how they're culling and getting to the right information and really evaluating and looking across large volumes of information very fast so that we can address, especially, in antitrust and compliance and all the things where we have to do things quickly, right? So instead of hiring lawyers all over the world so that we have 24/7, coverage to be able to get to the date that we have to, we're able to now use this tech. Do you think that the council really understands the difference? And judges understand the difference between this very advanced tech and using Chat GPT?
Yes and no. I mean, it's the old some do and some don't.
Right.
And, the lawyers who use it without really understanding it are more likely to get the industry in trouble.
Yeah, I would agree.
They'll do something wrong, and then they'll be in front of the judge and not able to explain what they did, and the judge may or may not, be sufficiently knowledgeable to work it through.
Do you see yourself having a role in helping to a continued role, because you already have had a role, but a continued role in helping to get the courts more comfortable with this? And are there other judges that you confer with that agree that this tech is here to stay and we need to get more comfortable and we need to establish education, at least for uh, the industry, around getting comfortable with this technology?
I mean, there is a limited amount of training for the federal judiciary. State courts are much more the wild, wild west. And how much or how little they get varies very much state by state. The Federal Judicial Center does certain industry, judge-wide conferences, but there's the budget. And so when they do these eDiscovery training programs, there's maybe budget for 30 judges a year. That there are about 1,000, maybe more, district and magistrate judges, and then throw some circuit judges who care into the mix. That's what, 30 years to get through everybody, or whatever the math is on that. And it's hard, I think, for the judiciary to accept training from people outside it.
Of course,
in a very organized and approved way, for fear that somebody will say, the Southern District of New York brought in somebody who was a trainer, but they're a former, they're a former judge, but they're mostly doing defense work now. That's not fair, etc.
I'm going to be the voice of optimism here and say that the judges are, as the judges are going to want and need this training, because AI is ubiquitous, because they use it every day, because they use it at home, because their sons and daughters and grandchildren, and because all of us are using it. I think they will be genuinely curious. If you were sitting a judge and you're like, oh, tell me about eDiscovery in like 20 years ago or 15 years ago, I don't think that was going home with them at night. But I think, ChatGPT, Copilot, Claude, Perplexity, etc. Like, this is part of everybody's everyday life. And the more they understand, the better they are, in their world as we know it. So, Nicole, I'm going to say that you, as an educator, right, Epic as educators in the world as we know it, as one of the top legal service providers, your job is going to be much easier here than it was with TAR, back in the day.
Yep. I agree with you.
Yeah, I totally agree too. And I have to say, it's interesting. Our CFO of Epic came to me one day, or happened to be walking by, and said, I now have to sign on our financials that AI was used in creating those financials, and that we've confirmed the information, right? Because AI is now in pretty much every application we're using. And so you have to, there is that next step. And I appreciated that, because it's so true. I mean, every application that we're all using, most of them, if not, probably 90%, have integrated some AI into those applications. So everything going on. It's interesting. I love the idea of a science day and really educating the court. Hey, this is what was used to create, the producing party and the requesting party getting together, agreeing that this content that's being presented they're comfortable with it, and then educating the court. This is how is gathered. These are the tools that were used. We're both in agreement. I think, what an opportunity for us, one matter at a time, to go ahead and educate. Fantastic. Yeah.
And to me, that is the job of the lawyers in a case, is to do that case-specific, judge-specific education or knowledge creation, knowledge confirmation. But I don't think it's going to happen nearly as much when you said the parties agreed on this. They may agree on doing a science day, but if they agree on, how we're doing the discovery, the odds are that most judges will say, thank you very much. When you're done and you're ready for your motion for summary judgment, come back. I don't need to know.
Right.
As long as you're not fighting about it, I'm perfectly happy. But in most cases where there is a little bit of disagreement, that sort of education, and whether it's a science day, whether it's going in on a, where there is a motion to compel, and not only bringing the lawyer, but bringing someone from Epic or, someone from wherever to further explain, that is very, very helpful to the court.
Judge, can I switch? I just want to switch gears here for a second, because this is a very unique opportunity for the community here. If you could put your DLA hat on for a moment and talk about your peers and colleagues, not your judicial peers and colleagues, but your legal peers and colleagues. How do you see their appetite, right? So here's DLA and 20 other major law firms that are leaders in this space, as we always have a bell curve, right? So there's 20 leaders. How do you see this appetite for learning and training and working with the judiciary in education now that you're on the other side? What comes up for you?
I think we are, if not unique, we're certainly, one of a very small number. We have a whole AI group that
Mm-hmm.
works on AI, not so much for discovery, but helping clients with all forms of AI that they're using or thinking about using. We red team on certain things, which is to
There you
say,
go.
the client says, we're thinking of buying XYZ tool to do our financial statements. Take a look at it and make sure it really does work and that it's not going to put in an extra penny on everything, which sounds insignificant, but you add it all up. And if someone is collecting those pennies and we don't know about it, pretty soon you get into real money. So we've got a whole team on that. So, and that is separate from our eDiscovery group. So we are well ahead of the bell curve on that. Other firms do it differently or do it, just for the eDiscovery side of things and have, various lawyers who are very familiar with tools, and then they go and help the rest of their lawyers deal with it. But I think we are probably unique with our AI group.
Nicole, at the risk of leading the witness, I want to suggest that it would be a wonderful opportunity to introduce Judge Peck to Roger Pilk in New York
Oh, yeah.
on Thursday, September 25th at the Solid Summit at the Westin. I think that hearing the two of them go at it and chat about where we are, where we're going, what's now, what's next, and looking into the crystal ball. I mean, again, I don't want to lead the witness, Judge, but I do think it might be a marvelous opportunity for everyone to hear the two of you kind of share and exchange your thoughts and ideas. Nicole, what do you think?
Oh, I think it's great. I mean, I know Roger would enjoy it. I mean, he is, obviously loves great conversations about the industry that we're in, and he would have many questions because, again, as our investment, it was made because we feel very strongly this is the way the industry is going, and we want to, as I always say to my team, everything we write about AI has to look at the positive side. Right. We want to be careful and we want to, do right by our clients, but we want to look at this as there is a way to do this a correct way. And that is our philosophy. So I would love that. David, if Judge Peck can make that, we'll make it work.
We can talk off podcast about what my schedule looks like.
Okay.
Judge, I'm going to have my agent call your agent, call Roger's agent, and coordinate and orchestrate with Nicole's agent orchestration over there at Epic. Judge, do you have any questions for us, or any questions that you want to ask the audience, or any advice that you want to share before we close up here today? And I have a song for you, just so you know, as we exit out here. But I'll let you have the final word.
I'm a little worried, but we'll see. I really have two final comments, one of which I made, but I want to emphasize it, and the other of which is off topic, but it's still eDiscovery. Be very careful. Learn as much as you can about the judge you're in front of and decide whether having this fight on a particular case is worth it, or, do something to work it out with the other side. Settle the whole case. That might be a little bit over the top, but and David, you may remember Special Master Whitaker and
Yes, I do.
When we were in Sydney, we're talking to this lawyer who was talking about a case he had where they were using tar, and he was very concerned about how the judge was going to react. And Steve Whitaker and I both said, if you can't, educate the judge, do something differently. You don't want a bad opinion. We're still in the very infancy. And that's what scares me the most about lawyer use of tar. Doing something wrong with it in eDiscovery and getting in front of a judge who doesn't understand it, or who understands it very well and knows that what he did was, totally wrong. So be careful there, because, tar, we're 13 years after my De Silva Moore case, and use of tar is still not where it should be. there's still too many, eyes on review, keyword search, all of that
Yep.
without using any more sophisticated tools. And the final point, just because I always say this, and you can cut it out if it's too off topic, everybody should look carefully and particularly on the defense side, make sure you have a federal rule of evidence 502D, D as in district, non-waiver of privilege order from the court. No matter what tool we're using, from the old-fashioned eyes on review to the most advanced AI, some privileged document is going to slip through in production, and you want to be able to easily get it back without an argument as to whether you waived privilege. So I've always said, get a 502D order in every case.
Great advice, Judge. Nicole, final thoughts?
Wow, this has been enjoyable, and I just appreciate the comment around, making sure that we don't do we're careful. I'm right, because we don't want to spoil this for the whole industry. So let's make sure, and lawyers, I always say there's a lot of great lawyers out there, right? So we just want them to all do their job and then rely on their support structure. I mean, we take it seriously as a company that people are relying on us, right, to represent, their clients, the lawyers that we work with. So I appreciate the fact that you're emphasizing that, because this is important, right? We don't want to step backwards. We want to go forward.
Judge, I knew that you would appreciate not only the song, but the name of the artist, because his name is Shorty Long, right? And I let that hang, Shorty Long. What a great name for a singer. And so, Judge, this is for you. I hope to see you in New York on the 25th.
Hear ye, hear ye. The court's in session. The court's in session now. Here comes the judge. Here comes the judge. Here comes
the judge. Judge Peck, Nicole Giantonio. What a fun episode. Thank you for joining us on Careers and the Business of Law.
Thank you both.
If you enjoyed this show, be sure to give us a like and subscribe on Apple Podcasts, Spotify, or anywhere else you get your shows. And if you want to take your career from now to next, never eat alone.